Order is 30,
Yes.
5/2026.
Page 39.
Copy applied on 2nd, 89.
Yes. Page 89.
Copy applied on 2nd,
On 4th ready,
Fourth.
I need to ready.
4th requisites, 5th they are delivering. Why they delay them?
Let me get instruction,
But
because
we are passing an order. No person will be taken from the foreigners tribunal without service of a copy of the opinion.
that's why, my lord, but
No,
ask the-
no, that you obtain of opinion, but this would prevent the court to pass an order. This would be highly illegal. You see what happens in the sessions trial or any criminal trial. This order is pronounced. Then the people are heard on the sentence, and therefore the orders of sentence are passed. And immediately thereafter, the copy of the order and the committal, what you call custody orders or custody memos are prepared and given it to the bench assistant. On that basis, they are given. And when they are taken into custody, they are permitted to have a copy. A pre-copy is delivered. Once you are taking that, the same principle has to apply here.
Pre-copy, my lord, whether probably whether pre-copy, this is a certified copy applied by them.
But you are taking to custody, you see, that is happening in the presence of the magistrate. In my court premises, the police will not enter from any place and take into custody anyone without the
Yes.
court administration knowing that has happened. You know the case of Niradath.
I know.
He was taken into custody from the court premises, and that is why the custody case was registered. That happened inside the courtroom. So
Let
if
me get it.
inside the courtroom somebody is being arrested, then our management would know about it. The registry will know about it. Somebody has been arrested from here. Even in the tribunal, the police is coming in and arresting someone. It can't be that the foreigners tribunal will be oblivious of people being arrested.
That is true, my lord. Let
Even
me
then,
get
if you supply
let me get
certified
get-
copy.
let me get the instruction on
Get
this.
the information
My lord, you have kindly say SOP, my lord, that will be more clear. my lord.
from today, no one will be taken into custody without the delivering a copy of the order. This can't happen. Because you are curtailing fundamental right to appeal.
No, no,
A writ petition
Why
might
I-
have been filed, but you are not even waiting for a day. Taking into custody, taking into detention camp, from detention camp, they vanish. No information to that won't be problem.
my lord, why I am saying, my lord, I'm asking for, praying for instead,
We are
getting
giving
some
time for instructions, but
Yes, my lord.
henceforth, nothing
But-
could happen.
One thing your lordship will, my lord, appreciate. There are some cases where your lordship is, my lord, known about that cases. One person who have been declared to be a foreigner, he approached the honorable court. He filed a writ petition, he got an interim order. Then in another case, his brother was proceeding that case. He appeared in that case, saying that I am the brother. And he continued the case, my lord. He continued. In fact, in entire proceeding, he appeared as the same person, another person. Then on the last day of my lord, when the opinion is passed, he said that I'm not the person. He tried to leave the court.
It's not that case.
Yes, my lord, no, my lord, these are the instances. He tried to leave the court, my lord, run away from the court. Then he was picked up, he was taken in custody. So there are some issues, my lord. That's why I want to get the instruction under what circumstance they were detained on the same day.
Henceforth, from now
No,
on.
that is true, my lord. For natural justice, that is true. I admit, my lord, for natural justice, if the free opinion is not served, then definitely they should not be taken into custody. That's my opinion also. Because unless the opinion is served, free copy of the opinion can be served to him.
We are not inclined to entertain, but this is from the same tribunal, both the cases are from same tribunal, same presiding officers, and same saying that after the High Court passes an order, this is how they will take.
Yeah, within half an hour, madam. Within half an hour of my appearance. Police call.
Members are different projects.
Your opinion, maybe it is. Members could transfer proposal.
Sophie was available. It's one member phone. You go member phone. I'm not this one, this one, who could have been.
The issue will escalate to different, it will escalate to a different connotation. Number one, when we are using those words, we are using it very carefully. Number one, foreigners tribunal is not a court of with criminal jurisdiction. Therefore, CRPC does not apply. It is a civil court for the purpose of determination and orders. Civil CRPC would not apply.
Yes.
Therefore, the foreigners tribunal will not issue a custody warrant.
Definitely, madam.
Correct.
Generally, foreigners definitely.
Therefore, when the person was arrested, at that time, there would be no custody warrant with the police.
Yes.
But they will be arresting them on the basis of what? On the basis of some opinion.
Yes.
So they'll have to produce the records of the police station, because they would have to show an entry that on the basis of this warrant we have arrested. So it will go out of your hand.
Madam, definitely, madam, it is civilian nature. But on the date of filing the WS, they have to be there.
No, you forget about that. They are the worst people on the earth. Can you hang them? No. They will be following the procedure established in law.
Yes.
Now, what is the procedure for taking into custody? How will the police take into custody? Police will take into custody on the basis of some judgment or order. So they would have the information, and they would write in the Thana diary, what you call the police station diary, that received information about this opinion, and now we depute Constable A, B, C to go there and take him to custody from a particular place. Therefore, he will take a vehicle of the police station and then go to the tribunal and then take him into custody. So when we are calling for the record, we are calling for everything. They will have to show the command given by the superior officer to go to the tribunal and then arrest him. The police works on a command.
Yes.
So if the command is not there, everything fails. So there will be a chain of documents which you are required to now produce. And if it is illegal, and if the person has vanished, then we have two ways to proceed to it. Number one, it will be the issue of the person vanishing from the custody with the improper procedure, and therefore compensation is the only palliative we can give. Therefore, that is why we are using those words very carefully. When you are using that custody warrant and all, tribunals will not be having it. So therefore, the tribunal's action, number one, to allow the police to enter into the court, tribunal premises and take someone into custody is a high-handedness which is expressly appearing on the record. So this business has to stop. Item number one, and in item number
Let the both matter may come together, my lord, day after tomorrow.
on Monday.
Monday. I'll get the instruction.
In item one, the opinion is at page 39. Actually, I'll dictate two orders. It will be better.
Well, before that, one thing, madam, just page 100, madam, just how procedure, how to,
Page
page 100. Their SOP, madam, they themselves came back. We start from page 98. And it is 1958, not applicable, but 100, they have stated removal of declared foreign nation of Java. Violation. After exhausting everything, well, then they put it.
versus in item number one. Item number one, and we say use the third under for the petitioner, and so and so for the respondents. Next. The case of the petitioner, in brief, is that by an opinion dated 7/6/2019, passed in page 19. Passed by so and so and so and so. The not the petitioner, the petitioner is the son of the then proceedee, namely Musammar Jahan Ara Begum, against whom the Learned Foreigners Tribunal Court, page 19. Passed an opinion dated 7/6/2019 in case number so and so, police reference number so and so, thereby declaring her to be a foreigner post 25 in 1960. The said proceeding had filed a writ petition being WBC 7546 of 2019, assailed the said opinion, and this court by order dated 24/4/2026 passed in the said writ petition, has set aside the opinion dated 7/6/2019, and the matter was remanded back for a press decision by the said learned tribunal after considering the evidence and materials on record. As the petitioner was absent before this court, the court had directed the learned tribunal to issue a notice to the petitioner and thereafter to dispose of the matter. Receipt of the notice, the proceeding appeared before the learned tribunal on 29/5/2026 and prayed for another date for hearing of the case. So, however, the learned tribunal, by rejecting the said petition number 312 of 2026, even to 6, dated 29/5/2026, stated to pronounce the fresh opinion dated 29/5/2026. The case of the petitioner is that the order of the tribunal was not made available on 29/5/2026, and the fresh opinion was actually pronounced on 30/5/2026. However, in the meantime, on 29/5/2026, the learned member from a foreigners tribunal, court from a Nagaon at Julia, called the border police for the tribunal and handed over the proceeding to them at about 1 p.m. It is projected that the records were made available only on 30/5/2026, and in the meantime, on 1/6/2026, the family of the petitioner and the family came to know that the proceeding has been sent to the transit camp at Matia, Gauhati. Petitioner, along with 2 others, went to the transit camp at Matia, Gauhati on 2/6/2026 and found the proceeding at the said camp. And they were allowed to meet and visit the proceeding. Now, so thereafter on 5/6/2026, petitioner along with another person had gone to the transit camp at Matia to obtain a signature in the Vatatama. Our Krishna was informed that the proceeding was not available in the transit camp and had been taken away by the border police. And since then, whereabouts are not known. You should notice returnable on Monday. 22/6/2026. Visit extra copies of the writ petition along with all enclosures be handed over to the government. This is handed copy to the serious state and copy of border and matters. Along with the soft copy thereof. Because the Governor Standing Council for the European Border Matters who border matters as well as the learned CGC to get information of the whereabouts of the proceeding, namely Jahanara Begum. They also direct the superintendent of police in Cricket Border, that was compound, within bracket respond number 6. Provide instructions to the Governor Standing Council for the border and FT matters, along with the relevant documents on the basis of which the border police had taken Jahanara Begum into custody and also to produce the copy of the journal diary entries of the concerned police station of (29/5/2026). the Superintendent of Police didn't take an order that it was now gone. He is also directed to that if in the meantime, Mr. Jana Begum, the proceeding in FT case number 312 of 2026, against whom an opinion dated 29/5/2026 was passed, has not been deported, she shall not be deported out of the country without order of the court. Next, because the Standing Council for the FT and Border Matters to send a download to copy this order to the respondent number 6 in order to obtain instructions. We also put all the respondents to notice to show cause as to why appropriate orders would not be passed by the court. To the effect that without being provided with a free copy of the opinion, that when a declared foreign national is being taken into custody from the premises or from the vicinity of the foreigners tribunal, why such proceedings should not be handed over a free copy of the opinion of the tribunal before taking him or her into custody. If the arrest, if the arrest or detention is being made on the date when the opinion is passed. Just take look like this. In the event the declared foreign national is being taken into custody on the date on which the opinion is passed, why a free copy thereof should not be provided to such detained person or any family member before removing the detained foreign national from the jurisdiction of the concerned police station. So as to bring the to bring the procedure in consonance with Article 22 of the Constitution of India. Next paragraph. On this point, the Standing Council for the Border and FT matters shall send a document copy of this order to the respondent numbers 2, 3, 4, 6, 7 and 8. So the patient shall send the download cover disorder to the respondent number 1 and 5. And the learned additional senior government advocate shall send a download cover disorder to the respondent number 7. Next, for the for instructions on the developer, this is the matter on 22/6/2026. In the second case, it will be the same. The senior counsel, Mr. H.R. Chaudhary, active Bosnia, the first opinion. Is at page 77, dated 6/6/2018. Name of the proceeding is Mumtaz. The High Court order is at page 84, dated 24/2026. In WPC 8171 of 2019. This order is to demand the matter back and directing the petitioner to the proceeding to appear before this said learned tribunal on 30/5/2026. Next paragraph. So this is 30/5/2026. At about 12:30 p.m., when the proceeding appeared before the learned tribunal and showed him the and produced the certified copy of the order dated 24/2026, passed in WPC 8171 of 2019. The learned member had become furious and called the police at about 1 p.m. to the tribunal, and from the tribunal premises, the proceeding was taken to Julia police station. And the petitioner had also accompanied her to the police station. It is projected that no order was passed on 30/5/2026. It is projected that on 1/6/2026, the petitioner went to the transit camp at Madhya, Valpara, and was allowed to meet the proceeding. And when the petitioner went again, the said camp to obtain signature of the ticket for national on 8/6/2026, he was informed that the declared foreign national was taken back by the police to Nagaon. And since then, the whereabouts of the why the petitioner is not known. It is also predicted that no order of the tribunal was declared on 35/2026. So the petitioner applied for a certified copy on 2/6/2026 from a certificate, and the requisites were paid, were deposited on 4/6/2026. Certificate copy was made available only on 5/6/2026. Just for the order to see.
ওটারও পাঁচ বছর লাগানো এখন
We are issuing notice of two aspects. First is about this, we get the information. Second is notice that why we will not invoke Article 22, read into these foreigners tribunal cases. When a detained person is being either taken into custody on the date when the order is followed. Therefore, then perhaps you have to follow the dictates of Article 20. That no arrest without serving of copy. Either to the proceeding or to the family member. That procedure will now lead into this. It can't be permitted. One wrong step will have a devastating effect on the entire procedure which is being followed. Do the state more harm than protection to the state.
My lord, yes, in some cases, my lord, we may consider, but in numbers of cases, your lordship will find, my lord. There is some issues.
Wrong, but this is something just too much.
Yes, my lord, there must be some mechanism.
One case you could have understood. But,
No, I admit, my lord, there must be some mechanism.
because not as accepted. When the second case of the same tribunal is coming and the same pattern, show the order of the High Court and they get affiliated.
No, that cannot be the, my lord, problem. My lord, this is in fact the procedure, my lord. I may be wrong. This was the procedure followed, my lord, in earlier by this honorable court in numbers of judgment. It is said they are absconding. So, my lord, they should present on the last day of opinion. In numbers of cases, there are judgments, my lord, where it is said they should appear on the last day of at the time of opinion. Yes.
You should not be honorary it for all
No.
the cases.
That is the general direction of this honorable court. But this, yes. Yes, my lord, the opinion is passed in the last day. There is the judgment of this honorable court. Way back in, my lord, 2000 itself, 2010. There is a specific, some direction to the government, my lord. Yes. Yes.
Are we justifying the order?
Yes. No, my lord, that is true, my lord. If my. Yes. No, my lord, my submission is definitely, there may be.
One more time we will.
Yes.
Tribunal itself, my lord.
No. That is not the way, my lord. In the tribunal, my lord, on that, yes, definitely there are procedures. No, my police does not, generally, police does not come to arrest, my lord, in the tribunal. It is only when some issues, my lord, there must be some issues where they were arrested.
My lord, my learned friend is justifying the order. You clear cut say yes,
No, no, no.
the order is right.
Order,
You
the
do whatever you like.
opinion,
Court is-
opinion can be silenced. Opinion can be silenced. Opinion can be silenced, definitely, my lord. We
I'm
have
not
no-
question telling you, the way how it was done, that is, I am
No,
clear on that.
that's why I need to give
You want to
instructions.
represent the
how-
government, it does not mean that you should be blind to the law.
Yes, Lordship.
Yes.
There's nothing not to be fair, Lordship. There are all these orders.
No,
You
I'm
couldn't
not
say.
saying, my lord, opinion should not be served to them. In fact,
They are
my
too
opinion
fair.
also that opinion should be served. Yes.
Court,
Yes, Lordship.
this SOP is there, madam. The subsequently SOP was made up. Let us, if you take the SOP is correct, you follow the SOP, that also you are not doing. Anyway, madam.
We are court officers. We have to place before the court both the judgments, Lordship.
They have also got some obligation to someone, madam, their problem. That's why I appreciate for that. No, I am not on that matter. Both the sides should be, I am not on that one. The way how it was done, madam, whole thing. And now I do not know where is my wife. So, madam, I am obliged to also. Only, madam, for the time being, what, any interim, madam, my deportation or anything or some. Yeah. Obliged.
My lord, if not deported to.
Before passing the order, you will deport her.
I
Is
don't
not
know,
that
my lord,
woman, that
no,
do
no,
it.
I don't know, my lord, where he is.
You must
because
have record
I may not,
that.
yes, I don't know. my
Time
lord,
may be
where-
accorded at what time your
He
lordship
may
passed the
already
order.
be deported also, my lord. He may already be deported also, because.
Only deported.
We don't know, my lord, because it's. What?
Anyway, my. If we open the mouth, many things will come, my. We are not also opening mouth. What that, how the things are going on, my. No, my lord. Because we want it today also, my lord. That's for our interest, my. Obliged to us. Yeah. That's all, my lord.
Yes, item two.
My lord, opinion at is 67,
The date.
18/09/2025, September 25.
It's 18/9/25. Sir, M. Ali.
Lordship.
It is 18/9/2025. Notice is to purpose. Property records. Below is 5,000 to the satisfaction of SP border, Superior Police border,
Walpa, my lord.
one plan. Make the address, transfer address, transfer address. Available in 4 weeks.
All right.
Item three,
Item 3, Lordship, opinion in case 61. My lord, page 61. Opinion dated 29/12/2025. SP border Pokrajhar, my lord. Lord. Obliged, my lord.
Item 4.
May I please, your lordship, kindly method may be passed over after some time, your lordship.
Lordship 24 order, Lordship may issue notice.
HG Daisy, on behalf of their. Obliged, your lordship.
May it please your lordship. Lordship, order is at page number 22, your lordship. Order dated 18/4/2024, your lordship. Borpeta, your lordship.
Third of August.
Obliged, your lordship.
Item 6.
May it please your lordship. Lordship, I am for the petitioner Musamman Afia Begum, your lordship, challenging the FT order, Learned Finance Tribunal order, FT4 D9/2019. Order is on your lordship, annexure 23, page 102. That was passed in 2020.
The reason of delay you have explained. You have explained the delay, why you have come up.
Your lordship, in the meantime, your lordship, Corona was there, your lordship. After that, health was very poor, financially as well as down. And then approached the authority to collect all the documents, certified copies. But it was delayed, your lordship, could not find the relevant documents in the meantime. Still, we are getting the documents, your lordship. It was continuous process, your lordship. We already tried many a times, but couldn't find relevant documents produced.
Delay with page
Your Lordship, delay-
33, Lordship.
It was not intentional, your Lordship.
Paragraph 33 not very satisfactory, Lordship.
Paragraph 33.
Paragraph 33, page 29. When COVID didn't continue till 23.
We have tried, your Lordship. It is a continuous process. But couldn't approach.
It may keep the issue of delay and mention a breach, Lordship, open.
Humbly submit that, your Lordship, delay is not intentional.
The name?
Your Lordship, Muhammad Afia Begum.
No, your name.
Your Lordship, M.A. Barbuya.
Can you keep working here?
M.A. Barbuya.
Is that page 102, dated 7/3/2020. Asked by so and so, case number so and so, PS case number so and so. Foreigner posted 590 University. Now, you the inordinate delay in listening to said opening, or keeping the issue of maintaining the open. Notice returnable on so and so. Therefore, bail shall be considered on receipt of the traveler's record. In the meantime, if the additional English also is obtained. There are 5 names. So, not be deported out of the country without before. No, we will not be able to pass an order in your case. The dispute of identity is Burma, please see page 34. First is page 34. Second, please come to page 2. Please, you have seen,
Yes, Lordship.
he has so many names,
Yes,
correct? 5 names.
5 names, even in the causes.
Give me cause the same name.
Yes,
Your Lordship, allow me to
Come
submit, your
to page
Lordship.
70.
70.
This name is not there in the affidavit. So she is a poor woman when it comes to these 5 names.
This is her sister.
Sister, your Lordship. Exhibited in, before the tribunal, your Lordship.
It is her sister who is deposed before.
All
the
brothers and one sister, your
Okay.
Then
Your first piece, no?
oblige, your Lordship.
take short they can have.
Yes, Lordship.
May I please, Lordship? My apology, Lordship, that the matter listed, Lordship, 28, Lordship, in a supplementary list, Lordship. And Lordship, kindly may be taken up the matter, Lordship, before raising this defense, Lordship, because the petitioner is in detention camp, Lordship.
90, 22, all corona, 28. Not call you.
Okay, we'll see, we don't know. So we have limited time. Okay, we'll try to take it up. Yes, item 7.
No. Page 25.
You have recovered
Recovering
23. Okay. Mr. D. K. Agarwal and Constituency Commissioner. Opinion is at page 25, dated 14/3/2023, passed by so and so. Case number so and so, reference case number so and so, by which the petitioner was declared to be a foreigner post 25 to 1973. Notice returnable on so and so. Notice extra copies. Call for the records. The prayer for bail shall be considered on receipt of the tribunal's records. In the meantime, with the petitioner, namely so and so alias so and so is apprehended, she shall not be deported out of the country without order of the court. Petitioner shall produce a certified copy of the order before the Superintendent of Police, Borpeta, bring the order to the notice of the said authority, list on so and so.
much of this.
Item 8.
Made, please, your Lordship.
Yes.
Lordship, opinion is that page number 34, your Lordship, another 2.
34,
34, your Lordship.
24.
Order dated 31/10/20.
A. Rahman, done counsel for the petitioner. Opinion is at page 34. Dated 31/10/2022. Same order. Will be considered receipt of the travel reports. The certified copy to be produced before the Superintendent of Police Border, Goalpara. Same order.
Obliging.
Item 9.
May it please, Your Honor. Lordship opinion is at page 30, Your Lordship. Opinion dated 8/5/2025.
Page?
30. Here, Your Lordship, I have not missed the verse.
You just missed it.
He just missed it by few days, Lordship.
Days.
Lordship may consider.
Your Lordship, I filed this on 7/5/2026.
You have filed on 7/5,
Yes, Your Lord.
order is 8/5. Okay, you're just on time.
Yes, Lordship,
Just
I
on time.
take that.
Okay. Third. Mr. S.K. Chakma, done counsel for the petitioner and also for the respondents. Opinion is at page 8/5/2025. Oh, sorry, 30, page 30, 8/5/2025, passed by so-and-so in so-and-so. Whereas the petitioner was declared to be a foreigner of 425 in 1971 scheme. You should notice returnable in 4 weeks. Extra copies, all for the records. The prayer for bail is opposed by the learned standing counsel for the FP and border matters. Considering the position, 10 days time, take bail of ₹5,000 to the satisfaction of Superintendent of Police
Boxer.
Border, Baksa.
Yes, Your Lord.
Let's start. After 4 weeks.
Deeply obliged.
Bail conditions. Yes, item 10.
May it please, Your Lordship. So, improving opinion in case number 19, Lordship.
19.
19. Date of order is 8/8/2025.
A. Hatim Muria, counsel for the petitioner. Opinion at page
Case number 19.
19. Page number 19. Dated 8/8/2025, passed by so-and-so in case number so-and-so. Reference number is down below. No? I have underlined it. Reference number so-and-so. Where which the petitioner was declared to be a foreigner post 25/3/1961. Notice returnability in 4 weeks. Notice call for the records. Extra copies within 2 days. The prayer for bail is opposed by the learned standing counsel for the FP and border matters. Considering the position, 10 days time to take bail or ₹5,000 to the satisfaction of Superintendent of Police Border, Bombay.
Then, no?
List of performance.
All right, Lordship.
Item 11.
May I please, Your Lordship. The implement for order is on page number 34, Your Lordship. This is an expiry order, Your Lordship, due to unserved notice, Your Lordship. The relevant portion is page number 35, my lord, paragraph 2, Your Lordship. I could not receive due to unavailable at the resident, my lord. But my lord, still that I have been deciding the third case. Same resident, your lordship. And as per this, in this regard, my lord, the local governor has been issued me a residential certificate, my lord. The same governor, my lord, Ikram Hussain, Governor. No any shifting is there, lordship. So, my lord, my humble prayer is that, my lordship, will consider this matter and my
Lordship, though it was not served, but the process has been followed. It was pasted on the place. His Lordship will examine this matter.
Passed by so and so in case number so and so, reference case number so and so. This is ex parte opinion, huh? Where is the petitioner is declared to be a foreigner post 25 and 97 USP. Returner belongs for instance, extra copies within. So call for the records, extra copy within 2 days. Therefore, bail shall be considered on receipt of the traveler's records. Therefore, bail shall. In the meantime, if the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court. This on so and so.
Delay Lordship of 6 years.
Paragraph 16, there are some explanations.
yes,
Lordship may keep it open for the moment, Lordship.
Notice, but keeping the issue of.
then interim, my lord.
Not to be deported, you have already passed that order.
Fix the date after
3rd of August.
file of this.
Item 12.
Yeah, please. This is a contested matter, your lordship. The impugn order is at page 42. Here I would like to highlight one thing, your lordship, at page 46 of the impugn order. Paragraph 14. Paragraph 14 is the only finding of the court, your lordship, whereas the other things are all that being deposited.
Let me examine, we can't do anything now.
Today you're getting bail.
But Mr. as Ahmed Learning Counsel for the petitioner. Page 42 dated 8/5/2025. Passed by so and so in case number so and so, FT case number so and so, by which the petitioner was declared to be a foreigner post 25 to 1971 scheme. Notice returnable on so and so. Extra copies of the notice, call for the records. The prayer for bail shall be considered on receipt of the traveler's records. In the meantime, if the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court. Petitioner shall cause production of a certified copy of the order before the Superintendent of Police border. Which place?
Nagaon,
Nagaon.
Lordship.
Nagaon.
Bring the order to the notice of the secretary. Based on so and so.
3rd of August.
Personally, intention may not be NSCC 58.
No, you have come after a month. You are using the thumb rule.
Supply item 25. promotion,
In this case, my lord was supposed to get the instruction. But when this Telamora Malad Tribunal constituted, this come to, Telamora was constituted in 2015, May. 2015. Yes,
But this opinion was rendered by the earlier tribunal in 2016, page 13.
16, May.
Yes.
No,
So
but
by then the tribunal is open.
yes.
You can transfer it to that place.
Yes, my lord, no issue. It can be transferred to that Telamora Tribunal. Because probably the case was continuing, running in the, my lord,
That is right.
number one,
That is
and
right.
it was fined in 2016.
That is right.
And there is no impediment within district because, my lord, the referral authority is the same person. Yes. Yes, ma'am. Yes. And jurisdiction tribunal. Hello. No, for evidence, madam. It resumed from for evidence, madam. Yes. Ma'am. How much? Yeah, the linkage, regarding linkage lordship in the regarding linkage lordship of the petition and lordship, there was document in the record lordship. Kindly peruse the earlier order lordship. There's a link document is available in the record lordship. Is with me, madam. Record is with me. Let us see. Yes. My lord.
Unless I look at the records, I'll not be, it'll, not be able to say what has happened.
Yes.
Only if I look at the records, I will remember.
Yes.
So you are satisfied?
Yes, there is some, my lord, yes, the land document of 1965.
No, I will not have a track.
Yes.
Unless I look at the records, I won't be able to say anything.
My lord, make it. The lordship has asked me to go through page 34 of the petition, my lord, that is.
Yes, now we recollect.
Yes.
What is-
So according to petitioner, my lord, the projected father my lord, had some land documents of 1965, 65 and 67 and 73. That is in my lord, page 34. In the WS also it is pleaded. That's why your lordship has asked me to go. And she has mentioned his brother and sister's name and even looked for it. Now only question arises, my lord. Thereafter, there is no apartment in WS. I have seen, my lord, that she has inherited that property of his projected father, of his father, in any time, my lord, before this WS is filed. That statement is not there. Yes, the land record shows, my lord, Rahmat Ali is there. Lordship, paragraph 10, lordship. Statement is there.
Don't interfere. When he
Sorry.
is making a submission, please don't
Sorry.
interfere. We take a serious office.
the proceeding citizen of, because the proceeding, her brother and sister name has been drawn up in
This
this
is
court.
not a game of cricket or football where you can give running commentaries when the other side is making surveillance. It's not that. Always remember.
So my submission was, my lord, that this statement in para 10, it is, my lord, that the proceedee is a citizen of India because the proceedee and her brother and sister name as a Jamabandi for service village in the village of Hasara, which are inherited by their father. Now, if your lordship may kindly see the Jamabandi which is exhibited by the proceedee whereby our name is shown. That is not the next hearing, that is in the record. That is it. It says Jamabandi executed by the proceeding, whereby one name is shown at serial number 24, my lord.
Yes.
Yes, serial number 24. But it that Jamabandi, my lord, if your lordship may kindly see, the father name is not there. But that means father is a pattadar is not there.
Just a moment.
And
Yes.
father, my lord, her name is there in serial number 24, but there is no mentioning of his father name in the as a pattadar prior to that, my lord. From serial number 1 onwards, I have checked it.
It is there.
Rahmat,
It is there. It is there. Serial number 4.
Rahmat Ali.
Yes.
Rahmat Ali, my lord, son of
Muhammad Ali is son of serial number 4. Khan Ali.
I misspoke.
Just a moment, Mr.
Yes.
Tell you, there's something perhaps you have missed.
Yes.
And you note, take note of in 85. And then 86. Take it to the one,
There are. Yep.
take to the root. First is that 86. No, not this one. First look at this next
Okay,
yes.
so, yes.
You have put a pencil mark there. Correct. Read that entry.
Prohibition চিফাৰ চক্ৰ বিষয়াৰ 26/7/95 তাৰিখৰ হুকুম মতে পত্ৰদাৰ আব্বাছ চাফেদ ৰহমতৰ লগত পৰিসূত্ৰে চিৰাজ আলীৰ নাম এক কথা
Yes.
দুইলেচৰ মাটিত নাম জাৰি কৰে।
He is the seller.
মানে
Rahmat Ali is the seller.
yes,
Rahmat Ali's name is at serial number 4.
yes,
So therefore, he is an existing patadar when this Jamabandi was prepared. Correct?
yes,
Because his entry is not there in the Jamabandi.
yes, his
So therefore,
entry
his original name is there.
yes,
So therefore, he will be the original patadar.
yes,
Now come to the previous page, 85. Yes, please open that. Now you will find the name of Rahmat Ali here.
yes.
This is of 65. So in 65, the pata contains the name of Rahmat Ali. Head of fourth name.
yes, madam.
Correct? So therefore, existence is in 65.
Yes,
Therefore, the second Jamabandi is that he is the seller in 95. But his name remains as the patadar, original patadar in 1965. So that is the link.
so this is there, my lord. I understood. But I have seen this document, my lord.
So it is only you see, Mr. Payang, it's a what you call constructional engineering we do.
Yes. No, I,
Since I am acquainted with this part, so it is easier for me to see some certain things. So therefore, we are trying to connect it because when there is a pata of 1965, what we thought is, or what we are thinking is that you may try to help A, B, or C, but you will not give them the original pata and the original sale deed. The original sale deed is there.
yes, cell deed is there. I have seen, my lord. Cell deed, sir,
You
there
may
are,
help someone with everything, but to give original document, there's some credibility as to relationship.
original, but original documents are there. But,
That is the only reason.
I
Could have
missed
been-
out this part, my lord, with regard to plot number. Here it is in page 65. Dag is 331, that is okay.
You
And
see, that is something which is lacking in the lawyer in the trial court. You see, at Jamabandi, when they are producing, they must know under the land revenue regulation how to connect the document, one document with the other.
yes, I missed this dark number, my lord.
Yes, okay, we don't
And-
blame you because the fact that
86 dark number is same. That but other, my lord, see, sale deeds, the earlier Jamabandi of the projected further, the dark number is different of law.
it have to be,
Yes,
it have to be. That is what I am saying, that they don't know how to how to prove a land record.
Again, but different here.
The time we're not in a hurry. You can examine it, you can see it again.
Yes, but I have seen it, but no issue. Only in para 26, para 9, page 26, para 9, that exhibit 9 has been dated.
You see, the traveler will make a mistake. The reason is we are not living there. They will need some assistance to read the document. These things were not explained in the evidence. Therefore, unless somebody knows how to read the land revenue records, they will not be able to find out anything. For that, we are not blaming them. The blame is to the council who is representing the petitioner. They don't know how to represent a document case.
Yes, ma'am. At least in evidence, my lord, they should give the that number of
Given
the.
otherwise, you see, I know about it because of my practice in the trial court.
Yes,
But everybody will not have that.
but because from the records, my lord,
Know how to read a land document.
from the evidence, it is not clear that there is a, my lord, that same, my lord, sale deed.
It's not available.
Yes,
That's why they they have a document and they become a foreigner because of lack of knowledge of the
yes.
conducting council. You see, there's exhibit 7 also is a Jamabandi. That Jamabandi is independent of exhibit 9.
Yes, ma'am.
So they don't know how to connect it.
That's why that exhibit 7 is totally different Jamabandi.
Yes.
Seems to be. It seems to be a totally separate,
It's in
separate.
respect of a different land.
Yes, different land. It's of a different land.
Yes. That is the land which arrived out of the other sale deed.
Yes.
After 65, there is another sale deed, but they have not been able to connect it.
Yes. But this patta relates to my lord the next amendment. When the petitioners came here.
The exhibit 7 perhaps is the Jamabandi relating to sale at 1967.
Yes.
But there is no connection. We also did not get it. So that is why we are giving you, we can take it some other day. We are not in a hurry.
Yes,
See, there are 3 sale deeds, 64, 65, 67,
yes,
and the other is 1973. We forgot the 73 for the time being. So out of these 3 sale deeds, there are 2 Jamabandi available.
yes, ma'am.
So
The first one is of 64. Let me see.
that is why we have not been able to know actually what is what.
Yes, it could not be connected with each other. ma'am.
Yes. And there is no clarity in the evidence.
Yes,
as to
that is the
what
problem, my
nature
lord.
of evidence.
Had there been clarity in evidence, it could easily, my lord, could be seen up. Because they, in the pleadings, in the evidence, they have not explained this properly. The tribunal also could not, my lord, get it.
No. So in fact, the evidence is clumsy. We don't get clarity of anything. Even the written statement is like that. There is no clarity as to which sale deed relates to which Jamabandi.
This Jamabandi is of, my lord, sale deed of, my lord, 1964. The first Jamabandi. The dark number is same. 144 dark number. Exhibit 7 is related to the sale deed of, my lord, 1964.
Okay, 64 deed is there, first
Yes.
sale deed.
Exhibit 2.
Yes, okay,
Exhibit 2 is related to, my lord, Exhibit 7.
okay.
Same duck number, 144 duck number. And the whole duck number in my lord, Exhibit 7 is 144. Then the Exhibit 3 is which relate to some 24, no, duck number 24
So
of
you,
Pastora village.
I'll tell you, Mr. Payne. The problem is that we are trying to connect things.
Yes.
I think it would be better to give that burden to Mr. Mazumdar. Let him file an affidavit, bring it on record, how you are linking the document.
No, yes. Then your lordship.
Because why should we spend our time in connecting the documents?
Yes, sir.
You file it, explain it to the, by way of an affidavit. What's his representative? EMS, Mazumdar, counsel to the petitioner. Please for some time to file an affidavit. Explain the land revenue, document related to land revenue. Specifically to link the various sale leads to the present land revenue records. Next, there is a matter sent at June today. This term, your date after. Some position. 17th of July.
My lord, I may be allowed to procure the document from the, I may be allowed to procure the document lordship from the,
So that you have to apply for.
Apply for
separate
applying
copy.
lot.
Can't permit that.
yes. Okay, that's okay. How do I go, the problem?
May I please lordship for dissemination item number 28 lordship. It is a very urgency matter, kindly fixed on Monday lordship.
Just one.
The petitioner is in detention camp lordship.
Item number? Item number?
28.
May I please, your lordship?
Opinion is at page 22.
Opinion is at which page?
Your lordship, 22, your lordship, opinion. You preferred an IA also, your lordship.
I for bail.
Lordship.
Yes,
Mr. Bain, when he's on bail, opinion of 29/4/26.
29 for
29
2026.
April 2026, your lordship.
No, well, let it. Common money.
We pass an order.
Yes. My lord, she is in detention, that's why they are,
Has to be released.
yes.
It's a recent opinion of 29/4. Page 22.
Yes.
G. Bharat and counsel for the petitioner who appears to video conferencing.
My lord, if I may permit some time, because if your lordship directs releasing order, I have to get instruction whether she may be deported also, then in that case it
No,
will
in that case, the order is that if not already
be
deported,
deported.
also had also for the respondents. Opinion is at page 22.
29.
22.
It is 29/4/2026, passed by so and so in FT case number so and so, SP border reference number so and so, by which the petitioner was declared to be a foreigner for 1971 stream. Notice returnable on given date after 5 weeks, returnable on so and so. Extra copies within 2 days. For extra copies, then you have to give it today. If extra copies in course of the day to day.
Lordship.
Call for the records. Next time, the land council for the submits that pursuant to the said opinion dated 29/4/2026, the petitioner has been taken into custody and he has filed a separate interlocutory application for bail. Next one, list on so and so. The IA. Heard so and so. By filing this interlocutory application, the applicant who is the petitioner in the connected rate petition has paid for bail. Next page is submitted that pursuant to the opinion dated 29/4/2026, the petitioner, namely so and so, has been taken into custody and she is presently detained in temporary jail, Bhatia Golpara. It is transit camp, Bhatia Golpara.
Yes.
Transit camp, Bhatia Golpara. Next one. The appear for bail is opposed by the Lawrence Standing Council for the FT and water matters. It is submitted that it may also be possible that pursuant to the petitioner being, applicant being taken into custody, he could have been reported by now. Next paragraph. Be that as it may, as the petitioner has, as the applicant has assailed the opinion dated 29 for 2026, passed in every case almost so, the reference on so, by filing the connected petition. The court is inclined to provide that in the event the petitioner has not been expelled from the country, shall be released on bail on furnishing a bail bond of ₹5,000 with one surety of like amount to the satisfaction of the Superintendent of Police Border, Nagaon. And you take the order from there, and there were 3 conditions on release of bail. The family member shall produce a certified copy of the order before the Superintendent of Police Border, Nagaon, and the said authority shall take steps for release of the petitioner from applicant from the transit camp Matia Gwalpara in 3 days. And in the meantime, to instruct the issue instructions not to, and in the meantime, on receipt of a certified copy of the order, issue instructions not to deport the applicant if not already deported. And within 3 days, to take steps for release of the petitioner, applicant. Those conditions are there. Application stands disposed of.
May please your lordship. Item number 13, lordship. Today is fixed for consideration of interim prayer, lordship. And the date may be fixed, with lordship, before the vacation.
Okay.
My lord, item 17 to 19, my lord. This may be taken up next week, my lord.
We don't know, we'll let the court master decide, because we will not be able to say it right now. Let them take a call. This is a matter which is part of that, item 30.
My lord, that is my lordship. There is some government, police department today file affidavit. Today we are file affidavit, she will get copy.
Okay.
Earlier, your lordship directed file to health department only, but parents department is police. So money will sanction from police department. So today we will file affidavit. Next week, any Wednesday, my lord, Wednesday or Thursday.
No, Wednesday, because we'll
Oh, yes, sir.
prepare to pass orders. Okay, in this item number
30.
30.
Yes.
You see, and is VR Svatana and legal aid counsel for the petitioner, and Mr. P. Sharma and an additional senior government advocate for the respondents. Additional senior government advocate has submitted that an affidavit is being filed in course of the day today by the
I give
respondent number,
seven.
respondent number 7. Let a copy thereof be served on the learned legal aid counsel. Next part, list the matter again on 24/6.
For pronouncement of judgment pertaining to Kohima bench, item 1.
For the reasons assigned, we have not found any infirmity with the decision of the learned single judge, and accordingly, the appeal stands dismissed.
My lord, I beg to mention one review petition, which is passed by this honorable court, my lord. Review, my lord, Monday. Sorry.
But I wish to mention item number 2, Lord. With the concept of the petitioner is lordship, and for a petitioner lordship, I pray for a legal accommodation lordship for today lordship. I pray for a legal accommodation for today lordship. I was supposed to file the affidavit lordship, but I have not received the instruction. So
This is 2024 matter.
lordship.
Affidavit not filed.
Affidavit lordship. I was required to file lordship, but due to some difficulty lordship, I did
How
not
much
get
time you need?
lordship. After vacation lordship, I have got to.
Make it last chance because it's 2024
Lord,
matter.
Lord.
What in that picture that what says represented on the claim made by Mr. A.R. Taibilwal, and it's standing counsel for the
Higher education department.
Higher Education Department.
Lord.
Last opportunity is granted to the respondents to file their affidavit, telling which the matter would be heard on the basis of materials available on record. Based on 2024 matter, give a date after the petition.
In July last part of July, or first week of August.
Yes,
In item number 18, my lord,
Apply the.
respondent authority yet to be filed affidavit, my lord. Item number 18, my lord.
yes,
My lord, matter will be taken after vacation. In the meantime, they supposed to file.
they filed the affidavit, no.
No, my lord.
Who's appearing for secondary education? Yes.
After vacation, madam, we will file.
24, it is also, my lord.
This is again a review of 2024.
Yes, my lord. They took time several occasions.
In review, why do you need to file an affidavit?
Yes.
Madam, we have completed on letter, madam.
Elementary and.
Elementary department works in the party, madam, and thereafter, we have completed here.
The Elementary Education Department is.
Elementary education, yes.
Okay. So you are appearing for secondary
I am
education?
for the secondary, yes.
Okay. You have been implicated in the review petition?
Yes.
Initially, school was MA.
Okay, it was on the School Education Department, now it has been bifurcated. Okay. Okay, both sides are represented.
Earlier under the elementary department.
I understand.
Yes.
On the claim made by Leonard Stanikosi for Secondary Education Department, one last opportunity is granted to the respondents to file their affidavit in opposition, failing which the matter would be heard on the basis of materials available on record. Next, list on the date.
I beg to mention item 14.
Item
14.14. I have taken concern from the petitioner. In this case, we are appearing for the respondent 2, 3, and 4. They are Cotton University.
Item 14.
14th, 1-4. So we were supposed to file our affidavit and we have sent the affidavit for fitting.
Right, legal aid counsel, what is
Yes,
the matter about?
Yeah, I'm a legal aid counsel.
So what is the matter about?
This is about for his admission in the PhD. He's a person with disability. Admission subject wise, in that way, his reservation or another disability quota.
So there will be urgency in the matter.
Yes, ma'am.
Education 1 year has already been lost.
Yes.
Affidavit, we have been, sent for the fitting. It is not come out.
Who is the authority to give you the instructions?
Yes,
This will be signed by, it's not by whom?
by the register in charge of the Cotton University.
Lots of vacation. No, after vacation, yes, but a fixed date, I'll humbly pay for a fixed date because,
Any day. After vacation.
because for him urgency is there, Lord.
D Ghosh. So this way we just
Yes, Lord.
call for the record. Service D Ghosh, I'm legal aid counsel for the petitioner.
After vacation. 23, 24. Okay.
Declared made by Leonard Stanley's for the Cotton University. The one last opportunity is granted to the said respondents to file their affidavit. Next paragraph. The case of the petitioner is that he is a person with benchmark disability suffering from 80% locomotor disability, and accordingly able to be eligible for admission to PhD program, which his admission was denied in view of lack of any reservation. The present petition has been filed in Article 226 of the Constitution of India. Next one. As the matter relates to admission in the PhD program for higher education pursuit, all the respondent authorities are put to notice that in the event the affidavit in opposition is not filed within 2 weeks, within 13/7/2026, the court will make an endeavor to hear the matter on the basis of materials available on record. The respective standing counsel for the Cotton University and the standing counsel for the higher education department shall send a downloaded copy of this order to the respondents to bring the order to the notice of the said authority. Next paragraph. Based on 207/2026. So 13th you'll have to file.
13th of the file.
13th you have to file, and then the order of this court, you will transmit it to all the respondents, bring it to their notice. We are listing the matter on 20 July.
It is the 24th.
24th.
Next week, the same week. The Friday. In the meantime, we'll file affidavit. We'll send up for vetting, there's some correction in this affidavit.
The list on 24. Okay.
Already.
Deeply black.
Fine.
For admission, item 1.
In this matter, as per queries of the finance department, the second government secretary to the government of Assam has directed the director to take the steps, and accordingly, my lord, the records or information are being collected from the districts, my lord. And the director has informed that information are being compiled in the state level, and its uniformity and authenticities are being examined. Few information received lacks clarity, and few information from some
See,
districts
that
are yet to
information
be
you are
found.
having, that information you are already having, why you need a comparison?
But, some information is required as per the finance department, and so there is some.
You understand,
that's
you
all.
see, you are very vague. This petition was filed in 2024.
Yes,
And they are claiming the benefit of seventh pay commission.
yes,
So the benefit you are knowing.
Yes.
People who are working, you are knowing.
Yes.
Then what is the inquiry you are trying to make? Please give some clarity.
Because of 2023, they've been submitting proposals. There are in fact two parts to the prayer. One is with regard to the implementation of seventh pay commission benefits. And the other, we are of course seeking a pay parity to the extent of the graduate, postgraduate
Pay
scheme.
penalty, we don't know.
That's
This
another
matter
aspect,
has to go to the pay and anomaly committee.
Well,
They'll have to take a decision as to whether priority.
but their minus is there with us,
It's okay, but for the purpose of this seventh pay benefit,
So the purpose of seventh pay from 2023, they've been sending proposals. So I don't know what instructions they want to have it now.
madam, the relevant records has been examining by the directorate, office of the directorate of
you
various
see,
districts, madam.
that's a very easy answer.
Yes.
Today, if I start examining this writ petition, it has about 400 pages. It'll take me 2 days. So for 2 days, I will not be working for any other matter. There will be no adjudication in any other writ petition. Because we are examining.
Yes.
Will you like it?
No.
Then,
So, madam, some time frame may be given to the office of the directorate or.
you see, we have lot of space in the High Court. We will request your authorities to come here and we'll give a table and they will examine the records here and address us. They will instruct you and you will make your submission in the court.
Madam,
You have to tell
actually,
us what examination you are doing.
madam, actually, my various documents have to be come from the districts, madam. Various districts.
What document? Please tell us what document.
Yeah, not, it is specifically mentioned, but
You see, every list is now computerized.
yes,
It will be available. What you call from each treasury, you can find out how many people are drawing salary.
as per finance department information, madam, these points, the queries has been made in following points, madam. Number one, total exact number of vocational part-time teachers are required for equalization of pay. Number two, total financial implication. Number three, budgetary provisions are provided for 2025.
Just close that communication.
This is the earlier communication already communicated here, madam. And this is the written one.
please tell me. These are vocational teachers, right?
Yes, vocational teacher.
Do you have any difficulty in accepting this page 139 to 158? Page 150, 139 to 158 are the incumbent vocational teachers. Now, are you disputing this? Total exact number of vocational part-time teachers required for equalization of pay. Now, please tell me, I'm just asking a question because I am ignorant of it. That's why I'm asking. Now, in this list, let us assume that there are 100 people.
Yes.
Now, tell me one person in your government who has the spine to tell that we need 50 and 50 can be terminated. And who are the 50 people who should be terminated, and these are the 50 people who should be considered for examining. Has that exercise been done for any department in the state? No. Therefore, please tell me, how will somebody give a justification of how many vocational teachers are required to be regularized?
No, my lord, to be regularized, my lord, the financial implication also there, my lord.
We understand, if the
Yes.
pay is from 1 rupee to 2
And
rupee, the
financial
financial implication is 1 rupee.
Yes.
So where is the difficulty? What data you actually need? We need to understand what is the data you are collecting. Now in your chamber, supposing you have 3 juniors, you think that you need to keep only 2. So to one, what do you do to the one you don't want to keep? You tell him that I can't keep you. As simple as that.
Yes.
See, in this, if there is 100 people here, you don't want to keep 20, so give them a notice. Give them a golden handshake and the end of the matter. But please tell me which officer will do that exercise to tell that in this government department, out of 100 we need 20 and this 20, 80 and this 20 can be left.
Lord, after examining all these things, my lord, from directorate office, it goes to the secretary. And thereafter, secretary take the further process regarding the financial approval or others. After getting the financial approval, they allow the candidates.
But you see, you are asking for a data, total financial implication.
Yes.
If finance department is writing it, these people don't know how to work in finance. You go to market and buy milk.
Yes.
It was 50 rupees yesterday.
Yes.
Today is 52 rupees.
Yes, sir.
Now, what calculation do you need to know that the financial implication of buying a fresh liter of milk is 52 rupees only? You have 100 people, they are getting a salary of 100 rupees per person.
Yes.
100 into 100 is how much? 10,000.
Yes.
Now you have to pay 200 rupees to each. 100 people will be 20,000. Financial implication will be 10,000. What is the difficulty in making that calculation? And we need how many years to do it? Third is budgetary provision provided for 25-26. So if you have not regularized, how can you give a budget? 25-26 is gone. Please tell me what is workable in your query. I'm asking you because I don't know finance.
Time frame may be given to the officials and They have the all,
I'm asking because you say I don't need no finance. Just tell me what is your workable program in this? Never ending. You see that we presume that we will give you 3 weeks time till the vacation. If no affidavit is coming, we are putting it in the order that with the nature of queries, it appears that the authorities do not want to do a simple calculation, for which they are sending files from here to there, and therefore we will hear the matter on the basis of materials available on record. Also, is represented. The learned technicals from the school education department has submitted that the finance department, the finance within bracket PRU, practical department, is examining the matter, and the files have been returned to the school education department to examine the matter and to resubmit its views and clarification on certain points. So it is submitted that the district-wise data is being compiled, which is taking some time. Next para. The case of the petitioners is that they are vocational teachers, and owing to denial of pay parity and the denial of pay scale for the postgraduate teachers, though they are discharging same duties, the authorities have been sent 3 proposals on 12/7/2018, 10/10/2022, and 25/10/2023 respectively, for being granted benefit as per the recommendation made by the 7th Pay and Productivity Pay Commission. Next para. This rate petition is pending since it was filed on since 26/6/2024. Despite issuance of notice of motion were ordered dated 17/7/2024, the except for the respondent numbers 3, number 2 and respondent 3, no affidavit has been filed.
well, the respondent number 3 has filed the affidavit now.
Yes, 2 and 3, recorded that. Therefore, comma, the respondent numbers 1 and 2 have not yet, the respondent 1 and 2 have not yet filed their affidavit in opposition. Full stop. It is strange to note that when the departmental heads are calling for the report from the from district, they have not been able to compile the requisite data for nearly 2 years. Therefore, for my privacy appears that the respondents not very serious in responding to the writ petition. Nonetheless, comma, the court is inclined to grant time till time to the respondents till 15/7/2026 to file their affidavits, telling which the matter would be heard on the basis of materials available on record. Next paragraph, we request the learned standing on for the secondary education department, finance department, as well as the finance department to send the downloaded copy of this order to the concerned authorities. Next paragraph, this is the matter on 2/07/2026.
On behalf of Lordship, responding number 2, Lordship, they have filed the affidavit. Yes, sir.
It is there, finances file affidavit.
Well,
This one, only one. This one is. We have recorded two, but missed out in the. Yes, item 3.
May I please? In this item, FMO 8 has filed a affidavit. We are going to file a reply.
8. What says the representative? So the non-council will be response, there is some time to file. So some more time to file activity in opposition. Affidavit reply against the affidavit in opposition can be respond the rate. Understand it on the list on 27/20/2026. This was all sides.
Item 4.
Or may it please your lordship. My lord. Yes, may I place the facts, please? Man, I was appointed as the headmaster of Azara Soneswar High School. It was a venture school then, by the managing committee by an order of 31st of March 2008, following advertisement and interview. Now, thereafter, I was removed from service by an order of 26th of April 11. I filed a writ petition, my lord, 3019 of 11, assailing the order of removal, and the writ petition was allowed.
by an order dated 16/5/2012 at page 70, the operative part. If I may invite my lord's attention. 68 it starts, 70 is the operative part. Just a minute.
This, what is this?
My lordship,
Lordship, that instruction I have received, extending also the secondary education lordship. I am appealing on behalf.
No, instructions you already have, but no affidavit was filed.
Lordship, affidavit is filed, Lordship, but there is some subsequent development has come up, Lordship. And hearing was also held on 2nd of June, Lordship.
well, he is on a different track altogether.
Here.
He is totally on a different track altogether. My case is somewhere else and the instruction is somewhere else. May I present my,
No, we've not seen the instructions,
my lordship?
but the affidavit is not filed.
They have not filed an affidavit as required by the last order, my lord.
No, it's not here.
There was no compliance of the honorables of this High Court earlier also. That's what I was trying to place. They have not filed.
There is an affidavit in opposition, affidavit in reply,
Lordship,
but after that, in the last date,
that,
has been mentioned,
29th of January 26. Yes.
4/6/26, it says, this is the matter of 19/6 enabling the learned standards for secondary education to file an affidavit to bring on record instructions received by him.
Lordship.
So therefore, this instruction is there on that.
Yes, thereafter, Lordship, that your hearing was held, Lordship, in after this, Lordship, communication, Lordship, on 2nd of June.
But it's a different part altogether, nothing with the case.
Let him complete. Let him complete, otherwise why, how can I understand?
The report of that hearing, Lordship, is yet to received by me. That's why, Lordship, it is which incapacitates me to file this affidavit in opposition as directed, Lordship. If Lordship permits me, Lordship, at least 7 days time, Lordship, I can bring those instructions,
No, file an affidavit in such matters.
Lordship.
The hearing was done between both sides.
Both sides, Lordship.
The petitioner and the
All the parties were present, Lordship.
private respondent.
Lordship.
Okay, let him
But-
bring it on record.
It's okay, but if I may just add on, this case has nothing to do with any hearing whatsoever.
No, you see, you are questioning the, what do you call, the provincialization of the respondent as headmaster,
Lordship.
correct?
And also, the order at 29/1/26 passed by this honorable court.
The precise hearing which has been done.
No, this is nothing to do with this hearing, this one. Insofar as we were not provincialized, our services, that led up to a hearing following a court's order, It is that hearing which my colleague is referring to. It has nothing to do with the provincialization of the present headmaster.
That
Two are both different.
That
distinct
report
and
of the
different.
hearing be common record, Lordship.
That would have no bearing on this case, I am challenging the provincialization of the headmaster. On the count, it is indicated in the order dated 29/1/26 passed by this honorable court, It refers to that. The Lordship would kindly have that.
No, the inquiry is with regard to headmaster.
If I may place it this way, the order of provincialization did not include our names. We moved the statutory appeal. It was heard by another person who was not the appellate authority. Honorable Court directed to go to the appellate authority. Appellate authority held and said that no, reconsider again. We came to the court. This honorable court said, you do it in a time frame, decide what is to be done. It is in context of that the hearing has been held. This case is not that. This case is the headmaster whose services you have provincialized by the very order could not have been done so because of judicial pronouncements which were there and which are reflected in the order of 29th of January 26, in this honorable court's order, in this case.
You don't know what this letter refers to the provincialization of headmaster.
That's it.
Look at it.
I mean, there would be an order of provincialization,
That we don't know.
of course.
But the letter primarily says that it's for the consideration of headmaster.
Correct. If I may, if Lordship will allow me to rephrase my submission, there's a particular,
Look at this first.
that's different, That's good. I'll place this. There's a particular order which is impugned in this writ petition. That is 4th of January 21. That my lord finds at page 20. '22 is the chart. Lordship has it at 22. Wahidur Rahman, at chain number 1, as headmaster, we are challenging the provincialization of Wahidur Rahman, respond number 5 hearing, because of certain grounds ABC. We had also filed a writ petition separate, that is 400 of 2024, wherein we had said our non-inclusion in that list is bad in law. We had filed earlier also, and on that count, the Honorable Court said you go to a statutory authority, appellate authority. We had gone to the appellate authority, but our appeal was heard by another authority who was not the appellate authority. Thereafter, we came to the Honorable Court, and the Honorable Court said, all right, now the appellate authority would hear your matter. Appellate authority had heard the matter and said to redo the entire exercise. At this, we came again. All things were there, you take a call. Now the Honorable Court said that kindly do it within 2 months. Hear both of them, whatever is to be done. It not having done, a contemplation is pending, which is listed today before another Honorable Court, my lord. Now they say that in that one, some hearing has taken place. This would have an effect in the contempt petition, whatever do with my provincialization. This case simplicity is that respondent number 5 would not have been provincialized because of judicial pronouncements, which, if Lordship permits, I may place.
Yes.
My lord, I was appointed as a headmaster and removed from service by an order dated 26/4/2011, which I challenged in WPC 3019 of 11, which was allowed by an order dated 16/5/2012 at page 68. My termination was interfered with, page 68.
What was the order of 29/6/2011?
My lordships.
29/6/2011, what happened?
Up to June.
29/6/2011.
Oh, I'm sorry. This was an order passed 2011, my lord.
Yes, 29/6/2011, constituting of the school management. This is referred to in the judgment
But
of the court at page 35.
my lordship.
450.
Four 450 would be 21/6/11 at 55/59. 59.
That
59.
this order dated, impugn order dated 29/6/2011.
My lordship.
Appointing president and vice president of SMTC.
My lordship.
Because SMTC would appoint the headmaster.
That was held to be bad. I'll place it, in the sequence. If lordship permits, I'll place it in the way the orders came. So when my removal by an order dated 26/4/11 was interfered by this honorable court at page 68 and 70, the date is 16/5/2012. Page 68 is the order of this honorable court, and the operative part is at page 70.
Because we are litigating so much, where do you have time to teach students?
And now it's again that their appointment is, I would not say.
Whatever is there, there was judicial pronouncement, flouting them, the headmaster is continuing, even, that is the order at page, by this honorable court, 29th of January. The last part at page 70, my lord. That being the position, if I have my lordship may read, the decision of the Assistant Inspector of Schools dated 24/6/11, removing the petitioner, that's me, from service, and the subsequent communication issued by the President of the School Management Committee are set aside. In view of the above, any subsequent appointment made to the post of headmaster in place of the petitioner shall be of no legal consequence. So in my place, if anyone is appointed, it will be of no legal consequence. They moved in appeal, page 73.
Yes.
They moved in appeal at page 73. Wahidur Rahman moved in appeal and the precedent below. By an order of 25th of July 2012, the operative part at page 74, my lord.
Yes.
We have heard, may I read from that part, somewhere middle.
Yes.
We have heard the learned counsel for the parties. It is undisputed that the impugned termination order does not comply with the requirement of section 15 of the Act, in absence of which the said order has no legal sanctity. Thus, we do not find any ground to interfere with the view taken by the learned single judge. Learned counsel for the appellant states that the managing committee had conducted an inquiry and found the appointment by the previous managing committee to be illegal and non-existent. The said inquiry is not shown as per section 15 of the Act. It is clear from letter of the appointment that the writ petitioner was appointed by the president and secretary of the managing committee. She is also shown to have dealt with the school funds. It would not be held that her appointment was non-existent. In view of the above, the appeal is disposed of. It is, however, made clear that this will not debar the managing committee from proceeding in accordance with law for taking any fresh decision. So therefore, the order by the honorable single judge that I would continue, my removal was set aside, and that any subsequent appointment made to the post of headmaster in place of the petitioner shall be of no legal consequence, was affirmed. Now, 1/7/2011, 1/7/2011 at page 53. The present headmaster was appointed. Page 53. Pausing for a moment, my lord. 1/7/2011 is after, 1/7/2011 continues, my lord. And in view of 16/5/12, 1/7/11 is after my removal. My removal is 26/4/11. My removal is 26/4/11. After my removal, 1/7/11, the present headmaster comes in. My removal would be 26/4/11.
2011.
26/4/11, my removal. Thereafter, 1/7/11, the present private respondent comes in as the headmaster.
26/4/11 you are removed.
26/4/11, my removal. Correct. My removal.
Yes.
And 1/7/11 at page 53 is the private respondent coming in as a headmaster.
Respondent number?
5. 5. Now, 16/5/12 at page 68 and 70, below. 16/5/12, where my removal was held to be bad in law, and it was said that any person coming in my place, any subsequent appointment made to the post of headmaster in place of the petitioner shall be of no legal consequence. Necessarily, the appointment of the private respondent stood invalid by the order of the Honorable High Court. This was carried in appeal by the private respondent. Appeal was not allowed. It was in my favor. Therefore, 1/7/11, the appointment and the continuance of the private respondents was essentially bad in law in terms of the directions passed by this Honorable High Court. Again, we had filed a writ petition, that is WPC 4450 of 2015, where we had challenged the constitution of the managing committee which had appointed the present headmaster. The order to that is at page 55 and 59. Page 55, the order starts in WPC 445015, and the operative part at page 59, my lord. 59, the last paragraph, if I may read. Yes. From the second last paragraph, if I may read. Therefore, the second last paragraph, somewhere in the middle. Therefore, the said managing committee. Yes. Therefore, the said managing committee being constituted in violation of the provisions of Assam Non-Governmental Educational Institution Regularization and Management Act 2006 with regard to Azra Soneshwar High School is bad in law. Further, any such decision taken by the SMDC constituted by the Inspector of Schools, Kamrup District Circle, Guwahati, in violation of Section 12 of the Act is also bad in law and honest in the eye of law. Further, it is also noticed that the said SMDC of the school in question illegally constituted by the Inspector of Schools, Kamrup, Guwahati by the impugned order dated 29/6/11 and further appointed the President and Vice President of the said SMDC by school by 26/6/12 have already completed his 5 years terms, spent its force and no longer in existence. So the then managing committee, which was there when appointing the private respondent, was also had to be bad in law at that relevant point of time. The third thing against him. And the last one, my lord. Insofar as, I'm sorry. Yes. Insofar as appointment of the private respondent as the headmaster and continuance, we had filed a writ petition WPC 1260 of 2012, which was decided at page 71 below. Operative part at page 72, one liner. Yes. It reads, and if I may read below, in view of the order passed today, 16/5/12 in WPC 3019 of 11, no further order is necessary in this case. Meaning thereby, my removal being held bad in law, and the headmaster cannot continue being held in that place. The same day, the same order says, because it is passed there, no further order is necessary in this case. After all these orders, judicial orders, he not only continued in service, but also was provincialized. So far as our non-provincialist part is concerned, that took a different route, albeit it was connected at juncture at times, but it has nothing to do with the challenge we are doing here. Here, what we are saying is, your action is bad on 2 counts. One, you have allowed a person to continue in violation of the Honorable High Court's order. Number 2, you have also provincialized him. But this action of yours, vis-a-vis our non-consideration in a different case altogether, which we are pursuing. Of course, we will. The hearing has also been done. His thing should have been set aside, and I ought to have continued from that long. I'm not claiming any extra benefit out of that, but I'm just pointing out to this Honorable Court the extent of discriminatory treatment being meted out below. That's all. Nothing. And this Honorable Court's order at 29th of January 26, what you would have it, this court's order below, in this case. 29th of January 2026. Which page? No, this was an order passed in this case. When I had that they also pointed out these happenings in the chronological order. Paragraph number 2 onwards, if I may read. The petitioner first submitted that in view of orders passed by this court in WPC 3019 of 11, Writ Appeal 205 of 12, and the orders passed in WPC 4450 of 15, the case of the respondent number 5 ought not to have been considered for provincialization in the manner it has been done by the respondent authorities. Further pointed out that the affidavit in opposition filed by respondent number 3 does not address this same issue at all, although the same has been taken up with the writ petition. Faced with such a situation, learned counsel so-and-so appearing for respondent numbers 1, 2, 3 has prayed for accommodation to be allowed to file an affidavit, bringing on record the stand to respondent authorities with regard to the assertions made in the submissions of the learned counsel appearing for the petitioner. In that view, time was granted. Then why, after all these things, otherwise, straight away case for suo motu contempt, how could they continue on? I put that question to myself. And now they're talking of a hearing. That hearing is on my non-troublation part, that would be a different case altogether. Man whose appointment was held to be barren-in-law, continuous barren-in-law, held for 2012 onwards, and provincialized. I ought to have been in his place, whether or not my services were considered for this way or that. That's my case. And the service was complete on respondent number 5. There's a order of the Lavazima Court, 14th of May to 25, deemed to have been completed. He did not choose to appear and contest.
Yes. Lordship, before stating that, one thing I would like to clear, Lordship, in pursuance of the Lordship order dated 29/1/2026, Lordship, an affidavit has been drafted and sent for vetting by my learned friend, Lordship, that that the affidavit has to come after signing. Yes, I have been informed just now, Lordship.
Pardon me? Please
That
repeat again.
affidavit in opposition, Lordship, which is required to be filed, Lordship, in pursuance of order dated 29/1/2026, Lordship, has been sent for vetting by my learned friend, Lordship. But same has not come after necessary signature, Lordship. That
You filed it.
My lord, I have sent it for vetting to the inspector of school, and I have talked to the inspector of school, but inspector of school told me that certain development has occurred in this matter, my lord, and hearing also called for by the director in directorate office, my lord. And regarding her view or her instruction that the petitioner's appointment was totally fake, my lord. Here it is stated, my lord, that the records submitted by Srimati Sunita Kakoti reflects that during the year 2009-10, she received all financial benefits as a headmaster, and Syed Abdul Barik, Srimati Ponita Kyaut, MD Mustaqim Ahmed were also received benefits as assistant teachers of the state school. Surprisingly, Wahidur Rahman also submitted documents that he had received all financial benefits as a headmaster. And as such, to conform with the facts relating to trace out the genuinity of the person who had hold the post of headmaster, a letter was issued to Inspector of Schools, Kamrup Metro, this office letter number so and so dated 24/12/2021. In reply of the said letter, Inspector of School, Kamrup Metro confirmed that there is no record ever showing Srimati Sunita Kakoti as headmaster, and she never received any financial benefits as a headmaster of the state school. Devadatta Kyaut, who is husband of Sunita Kakoti, was an OPB teacher, and at the same time he was the headmaster of the school. The appointment of Srimati Sunita Kakoti, Syed Abdul Barik, Srimati Ponita Kyaut, and Srimati Muhammad Mustaqim Ahmed were approved by Devadatta Kyaut, and it is later verified that Devadatta Kyaut, who is husband of Sunita Kakoti, was an assistant teacher of Azara Suneswar ME School, was also acted as headmaster of Azara Suneswar High School in the year 2001. In the year 2005, Devadatta Kyaut appointed Sunita Kakoti as assistant teacher, and Her service was upgraded as headmaster in the year 2008. Later on, Devolata Kaut and Sunita Gauhati appointed Syed Abdul Barik, Srimati Panita Kaut, and Mohammad Mustaqim Ahmed. Hence, appointments and orders are invalid and manipulated. DSA order number so and so dated 30 August 2022 rejected the claims of the petitioners, and no available authenticated record of attendance registered against the Sunita Gauhati, Abdul Barik, Srimati Panita Kaut, and Mustaqim Ahmed.
But you see, that inquiry we can't take cognizance of.
So, my lord,
It
hearing
runs contrary to
report
the
of
judgment of this court.
yes.
If there's a judgment which says that the appointment of Council 5 is bad,
Yes.
we are not hearing a review. You have not filed any appeal or any review against that order.
Yes.
Bringing on record these things. So we'll have to omit whatever you are saying.
Even this was denied.
On the premises that once the High Court says that the appointment is, the removal is bad.
And one complaint is still pending, and today is listed in the code number 21.
That's a different matter altogether, my lord. Nothing to do with
Let
this.
him complete. Please don't disturb him. It's something I absolutely dislike.
I'm sorry.
So, my lord, sometime may be granted so that the full instruction
You
come.
must tell us, you see, you must tell them. The instructions they are providing is of no use. Will you accept it?
Yes.
Yes. If this instructions comes, will you defend that instructions?
Yes.
Can you do it?
Yes.
Then? If those instructions are correct, the respondent should have gone and filed an appeal against
Yes.
the order.
So, my lord, that the matter will come after vacation. And in the meantime, we will take the hold the discussion with the officials and take instruction and file the appeal.
You see, the difficulty is your prayer. You tell us a fact. That fact relates to something which is contrary to the judgment of this court, 16/5/2012. We can't possibly record it and then give you time for that. What we can only do is to give you an adjournment on your prayer. But that doesn't help us in any way. Let us say after 3 weeks you come with the same affidavit. How does it help us to adjudicate the matter? We'll have to proceed from from this order of 16/5/2012. And you're not telling us that for making those fake entries, you have filed any FIR, you have taken steps against this cure or against the present petitioner for the fraud they have committed. That is also not your case. The fact remains that the petitioner, having got an order in 2012 that the appointment, her removal is wrong. For now 14 years, she is continuing to be out. possibly can't, Mr. Sharma, you can't possibly repair the damage now. The fundamental point here would be that the appointment order of the respondent number 5 that was challenged in WBC 1260/2012. Yes, this court referred to the order of 16.5 and said that no order is required to be passed. That means 16.5 stands affirmed. Then the what you call the representation is is extremely bad from that point. And the second problem is with your prayer for adjournment is that we will be taking into cognizance of the fact that despite the High Court passing an order, you have done a hearing that is again contemptuous. That is something we can't permit.
So, my love, kindly grant us one time so that we can, after discussion with the officials, we can make our application.
This has Bunny Kilometer Senior Counsel assisted kindness. F. F. Begum. Senior Counsel to the petitioner. So, so Gupta, you are appealing for whom? That's it. Okay, perfect.
Good, Sharma.
You shall not run the counsel for the place for adjournment. On the ground that as per instructions received by him, hearing has taken place. Would be
My love, from the inspector of school.
before the inspector of schools.
Yes, sir.
Next part. From the materials placed by the for the petitioner, how it appears that this court by judgment and order dated 16/5/2012 passed in WPC 3019 of 2011 largely petition filed by the petitioner and held the held her termination to be bad. Accordingly, the decision of the Assistant Inspector of Schools dated 24/6/2011 by removing the petitioner from service was, and subsequent communications were set aside. The court recorded its view that any subsequent appointment made to the post of headmaster in place of the petitioner shall be of no legal consequence. Further providing that the petitioner shall continue as headmaster in the Azira, AZERA, Azira, Soneswar, SONESWAR, Soneswar High School. The short said order was assailed in intra court appeal. It was dismissed by order dated 25/7/2012. Passed in W8205 of 2012. In the meantime, the appointment of respondent number 5 to the post of headmaster of the said school was assailed by the petitioner by filing WBC 1260 of 2012. And this put by its order dated 16/4/2012 held that in view of order passed on 16/5/2012 in WBC 3019 of 2011, no further order was necessary in the case. In other words, this court had affirmed the hearing before referred order there is 16/5/2012, where any subsequent appointment made to the post of headmaster in place of the petitioner shall be of no legal consequence. Moreover, it has been placed that by an order dated 21/6/2017 passed in WBC 4450 of 2015, at the then managing committee, which had issued the appointment order dated 29/6/2011 in favor of the form of 5, was also held to be bad in law. Next, first form. The court fails to understand the purpose of the inspector of schools hearing the issue relating to appointment of responding in 5 as the headmaster, which because such hearing operates contrary to the order dated 16/5/2012 passed in WPC 3019 of 2011. Not on the ground assigned for adjournment, but on the prayer made by the council for the secondary education department. The matter stands adjourned today. This the matter for further resolution on 21/7/2026. You refer to your ground of adjournment, we say that it is not on that ground, but otherwise on your prayer, we are adjourning it. We have made our mind clear that the hearing would amounting to overreach of the orders of the court. Please take care.
Would my lord be pleased to consider the matter as part of it?
No,
Actually, something I don't have what you have. Very difficult to keep. Once we are in a different thing than me.
Would my lord to then please add one line to that, if I can. That there should be no further adjournment on any count whatsoever. Even if I am not there, my colleague is trying to address that, whatever she can. 14 years, my lord.
In view of 14 years of litigation suffered by the petitioner, provided that no further adjournment shall be granted on the date.
Very good.
Lordship, Mr. R. Pujari appears because of some medical condition, Lordship, he had to leave. And he has informed me, Lordship, that he has actually missed to communicate the last order to the department also, Lordship.
Updated instructions for proposing pension.
Yes,
Pension.
for pension from the Director of Accounts and Treasury, Lordship.
For
Yeah.
another year, this is pending.
Yes, Lordship, on the last date, on the 10th, Lordship, we were directed, Lordship, he has missed out, Lordship. So one small applause. First, immediately after the vacation, Lordship, I'll communicate, Lordship.
On behalf of Bhupatari, we are standing up to the Director of Accounts and Treasury, Assam. Case earlier, and standing up to the Finance Department pays for exam. As the understanding for the Director of Accounts and Treasury could not be present. The learning standing up for the Finance Department have surprised the standing up for the Director of Accounts and Treasury of the requirement to obtain updated instructions regarding the status of processing the pension proposal of the petitioner. Next one. Need to have both sides placed on, then
Lordship, any date after the vacation, as per my senior committee.
22/7/2026.
Obliged, Lordship. Obliged.
Sir, let me add one line. The pendency of this rate petition
Lord.
should not be a bar for the respondent authorities to process and release the pension if he's found entitled.
Lordship, my lord.
Obliged. This is ready.
My lord.
She is found entitled. Mr. Dutta, you also here in the matter? So take it, Dutta, can you complete for respondent one? One for instance.
Item 6.
In this matter, we can afford to directed to file affidavit matter. Accordingly, we have filed yesterday, and probably the affidavit is not on record. Yesterday, we have filed matter from the department matter. Respondent number 2. Matter relates to provincialization of Sara.
Okay, but this goes after vacation. We'll not be able to take up the hearing now. What's it, Representative? Standing for the. You are appealing for which department?
My lord,
You are appealing for which department?
affidavit by elementary education. As per the
Director of
director.
Elementary education department.
As per number 2, my lord.
Respondents to state level scrutiny committee.
My lord, represented by the director, my lord. So we have filed on behalf of director.
Standing up for the elementary education department has submitted that on behalf of the director of elementary education, an affidavit in opposition has been filed on 18/6/2026. So the said affidavit is not on record. Let the affidavit be brought on record. So, reply, if any, by the petitioner be filed by them, by the next date of this week. Next one.
After the
List on 22/7/2026. You have given him a copy?
Yes, madam.
Yes.
Copy.
Yes.
You said also as a representative.
Item 7.
7, my lord, I pray for written accommodation, my lord. Signed copy of affidavit received today itself, my lord. So we immediately after vacation or next week, maybe. We're going to file.
Give him a copy by,
We'll provide, my lord. Today itself, I. I put it ready to read.
also as a representative. For the next standing for the elementary education department. Submit that he has received a copy of the
Today, no.
copy of the affidavit in opposition to be filed by the respondent numbers 1 to 4. And shall be filed within 2 days. Next, the copy thereof be served on the then counsel for the petitioner. So that reply, if any, can be filed prior to the next date of this week. Based on 22/7/2026. Reply, if any, be filed by then.
My lord. God bless you.
Item 8.
My lord, I am appearing for a vacancy loss. Our instruction is here. Our instruction is here. Instructions since 2025, that is, and my lord.
No, last revision, I think.
Last, yeah, this is me, copy last First copies are first.
Similar type of cases have already been dismissed by the honorable coordinate plans of this honorable court.
No, the arguments are no longer there. After this, we got orders.
Regularization, you see, after a few years. How much time? Immediate after application, we will file our affidavit also, immediate after. Mr. D.P. Chalia, the senior counsel for the senior counsel assisted one is
M.
Roy, the counsel is present. Next one, Mr. B.C. Musahari. B.C. Musahari. Respondent number 2, 3, 8, 9, and 10. Respondent numbers 2, 3, 8, 9, and 10. 8, 9, and 10. Please for some more time to file affidavit in the matter. Next, as the issue is in the writ petition is regarding claim for regularization and area salary.
Cancel it.
No, payment of salary along with area. The said respondents have put to notice that in the event the said respondents fail to file their affidavit in opposition
So,
within the extended time of 17/7/2026. The matter shall be heard on the basis of materials available on record. Next, we request the journalist standing counsel for the BTC to transmit a downloaded copy of this order to all the concerned respondents to bring the order to their notice. Next, list on 22/7/2026. We are requesting you to send a downloaded copy of this order to the BTC. Please do it. You are appearing for whom?
For 4 and 5, my lord, elementary rules.
Elementary.
Item 9.
Yes, Mr. Bora.
My lord, after issuing notice, my lord, respondent authority have taken time on 4/6/2026 and 27/6/2024 for filing affidavit, my lord. But till today, they did not file an affidavit, and his salary was stopped 2007. In the meantime, he was appointed. In the meantime, he came before the honorable court. Honorable court directed to release him salary from 2007, area and current, my lord. But in the meantime, they give the appointment as a tutor. Well, I am challenging on the perception and thereafter, my director, my your lordship, go to your lordship ordered it is my lord.
Elementary education, what is there?
My lord. Space, my lord, 86, my lord. After issuing appointment of the tutor, my lord, the district elementary education officer, my lord, please make any change at 86. With reference to the subject cited, I have the honor to forward here with petition submitted by 4 numbers newly accommodated tutor belonging so and so. The concerned petitioner have prayed allowing the enjoy regular scale of pay as they had already completed the junior basic training and normal under SCRT as men. My name is CL number 1, my lord. But till today, they did not do anything, my lord.
Lordship,
So,
before
next
25,
year, my lord,
we have already written to the directorate has already written to the district elementary education officer, my lord. We are awaiting the paravised comments of the, my lord, the DEO. So, my lord, will give us some time because this is a contested matter, my lord, regarding area salary, my lord, and we'll be showcasing, my lord, a judgment, my lord, of a coordinate bench, my lord.
What is the file it?
I'll file it, my lord, within my lord.
perhaps
Lordship
this
will-
letter is, my lord, June, my lord, 5, my lord. And thereafter, 2 occasions, they takes time.
May, my lord. We are waiting, my lord. We have got instruction, my lord. So sometime we are taking, my lord.
2027.
Because, my lord, there are coordinate bench, he has taken appointment as a tutor, my lord. There is a coordinate bench judgment, my lord. We'll be placing it on record, my lord. With
I'm
that.
also coordinate division bench order was annexed,
So
my
we'll be annexing that
lord.
also, my
Page
lord.
87, my lord.
Lordship will have it,
Once the, this is a year-old matter and then
File.
affidavit is filed.
my lord, I'll ensure that it will be filed. I'm appearing today for the first time. Last chance, really given.
Both sides are represented. The learned standing counsel of the elementary education department pays for the 2 weeks time to file affidavit in opposition with the matter. For the next one. In this case, the petitioners have assailed their appointment as tutor for claiming that they were regularly appointed teachers. And therefore, they claim that the petitioners claim that their past service has to be calculated for all purposes. And therefore, on being appointed as tutors, they are debarred from claiming the benefit of past service. This court has also recorded in the order dated 4/6/2026 the apprehension of the petitioners that the petitioner would be retiring soon. Therefore, while granting the respondents the last opportunity to file their evidence or their affidavit in opposition, it is made clear that no affidavit is filed within the extended time. Matter would be, endeavor will be made to hear the matter on the basis of materials available on record. Next panel. We request the learned standing counsel for the elementary education department, as well as the learned standing counsel for the finance department. Mr. Alia was there. Finance department to send a downloaded copy of this order to the concerned respondents, bring this order to their notice. Next panel. Just for further consideration on 22/7/20. No, before that, you say that as the petitioner projects that he'll be retiring soon, it is made clear that on the next date of listing, no adjournment shall be granted to the respondents. It's on 22/7/2026.
Right.
Mr. Alia, this case, they are
Forwarding
granting the tutor
as you said.
status, they claim benefit of the past service.
Past service, yes, Lordship.
And he's 58 years,
Yes.
already he has crossed, he's in the 58th birthday.
Lordship.
So he will retire soon. So no adjournment on the next date.
Yes, but.
Please send a download copy of this order.
Mathful. Next is also similar phenomenon, but they are also not filed with ma'am.
Item 10.
Same order.
Similar order.
What is the age here of the petitioner? He's not retiring.
Is not prepared. Now he is my 55, 56. But
EPF letter.
Mr. Alia, if incidentally you don't have a copy of the writ petitions also, please take it from Mr. Bhagan.
I will take a copy from my friend.
Okay.
Item 11 with 12.
In this matter, my lord, Honorable Court directed me to produce the up-to-date instruction, my lord. I have received the instruction and I kindly take up the first and item 12, my lord. I have received the instruction and item 12, my lord. I seek some accommodation for regarding item 11, my lord. So kindly take up, my lord, item 11, my lord. This matter pertain to, my lord, they are provincialization on 5347. WC 5347. 12.
5347.
My lord. This matter pertain to their challenge that they have not received salary because, my lord, they are provincializers on the basis of SLC recommendation without DLC recommendation, my lord. So that when the EU searched the, my lord, the record found that they have not recommended by the DSC, my lord. So on, my lord, 2021, no? In the year 2021, they have been stopped for their salary, my lord. They claim, my lord. Subsequently, the hearing is conducted, my lord, and found that DSC is not recommended. So one speaking order, my lord, recently passed, my lord.
You bring it on affidavit, you see, this.
My lord, then And take it up from vacation, my lord. In the meantime, I will bring the rest. My lord,
petitions
that
will
is
know
better,
that
my
happening. Dispute matters is very difficult to take inspection.
My lord.
Which is represented. The Learned Standing also for the Elementary Education Department has submitted that he has received instructions and stays for some time to file affidavit. There is a law. As the petitioner claims non-payment of salary since 1/5/2022 till date is made clear that no further adjournment can be granted on the next date of this week. Next part, the affidavit shall be filed within 17/7/2026. Next part, this on 22/7/2026.
My lord.
You will file the affidavit by 17. We are taking it up on 22nd.
My lord.
We very clear no further adjournment. Do it. Look at this thing. Learned Standing also for the Elementary Education Department and send a downloaded copy of this order to the concerned respondent to bring the order to their office. This was.
Buddha, my lord.
Matters are both are separate orders.
Item 13.
No, please, your lordship. My lord, the matter pertains to compulsory appointment, your lordship. So, the father of the teacher was an LP, father of the prisoner was an LP school teacher, your lordship. Died on 23/6/1995, your lordship.
1995 years died. How will you entertain a repetition now?
So, lordship, may I allow to come? Lordship, right at that moment, your lordship, I have filed the representation, your lordship, before the
We
consent.
have this, what is that living case? He says after 2 years it has been spent force.
Yes, your lordship, Devabrata, your lordship.
Devabrata theory. Supreme Court judgment.
I put this.
Our court and honorable Justice Sultan.
My lord, there are some orders in favor of
Yeah,
the petitioner also,
series of
even if there is a
So, yeah.
considerable delay, your lordship. If it is the fault of the respondent, your lordship.
No, even if there is no fault.
My lord, my lord.
Even if there is no fault,
Yes, my lord. After 2 years. My lord.
So, my lord, there are so many judgments of the Honorable Supreme Court, your lordship, I have.
we have dealt with those.
Lordship.
We have dealt with all those orders.
Within time of the rule of. Two, 7, 3, 6. ये तो क्या बताओ available है?
There is Achyut Ranjan Das, my secretary remembers.
That earlier.
Yeah, that's a long back,
2006.
your lordship.
2006.
But still that's a living case.
And also Poziran Nasa is also there is another.
Subsequently, but my lord, the honorable, honorable Justice Jutamkar, my lord, passed series of judgment, my lord, regarding the in view of the my lord, Devabrata theory, my lord.
But lordship, here in this case, your lordship, because they himself admitted the fact that there is a, your lordship, some lapses or fault. Page 31 may kindly be looked into, lordship. page 31, Your Lordship. That is the minutes of the meeting, 16/12/2023, Your Lordship. Remarks clause, reason or remarks. And down below. Applicant father died on 23/6/1995 and submitted his application to the concerned department in appropriate time. In the meantime, there was no provision for DLC meeting. So the concerned department DEO Dorong had forwarded the application to the higher authority. Elementary Education Assam Kailiparan 19 to appoint him on compassionate ground in respect of deceased son so and so so and so. Now the deceased son has submitted another application on 30/08/2020. It is on the instruction of the respondent authority, Your Lordship. As the petitioner, Your Lordship, let me to this office. Accordingly, DEO has submitted the vacancy position of post 80 LPS and complete. Committee has decided to forward the proposal to the government for further necessary action. Now, Your Lordship, come to page, Your Lordship, I want to draw Your Lordship at page 36, Your Lordship. Page 36, that is the letter by the Deputy Commissioner to the Joint Secretary, Your Lordship. Page 36, Annexure 12.
Nothing will help you. There is a division bench judgment which has followed Devabrata Tiwari.
My lord.
And it is held that once the time period has lapsed, not be entitled to.
But Your Lordship, I have.
No, you see, the present, what is the present scenario?
So.
It will depend on the vacancy which existed then.
Yes, Your Lordship. Yes,
It is, can you now come and say that in 1995, that is the vacancy, please fill it up now?
But my submission to Your Lordship is that because 1995 I have submitted the representation, Your Lordship. My Your Lordship cause of action still continue, Your Lordship, because I have not abandoned, Your Lordship. Right from the very beginning, I am still under the legitimate expectation, Your Lordship. And there is a supporting some, Your Lordship. And Your Lordship, another judgment, and recent judgment, Your Lordship, that is Canara Bank versus Ajit Kumar. Para number, I don't have the, Your Lordship, the citation right now. That is discussed in para 27 and 28. That is, Your Lordship, against the Devabrata, Your Lordship, in counter of Devabrata, Your Lordship. That is also Supreme Court judgment. Canara Bank versus Ajit Kumar, GK judgment, para 27 and 28. For delay caused by the respondent. And also, Your Lordship, in WBC number 342/2025 before the Honorable High Court, Your Lordship, a bunch of writ petitions were there, decided, Your Lordship. They have challenged the OM 18/09/2024. I also, Your Lordship, following the target of the same category, Your Lordship, because here it is very specially indicated that before 1/4/2017, if somebody dies, Your Lordship, an application.
Canara Bank versus, what is the name?
Lordship, that is WBC number 342 Abdul Kadir Basti.
No, you said Canara Bank versus?
Canara Bank versus, Your Lordship, Canara Bank another versus M. Mahesh Kumar. That is your 2015 7 SCC 412, Your Lordship. Devabrata Tiwari to hall 23, 3/3/23. 15, but There's a latest judgment, your lordship, I don't have the copy, your lordship. Your lordship, allow me some other day, your lordship, I will.
No, we have that. Once you give us a judgment, we are ready with it.
Lordship, that is another judgment is there, your lordship. Canara Bank versus Ojit Kumar. I don't have the copy, your lordship. Yes, I have given another one. That is 2015 Canara Bank. It is 2000, I think, 25. Para 27, 28.
Yes. I think so.
Yes, and also your lordship, it is not that the petitioner should be, your lordship, posted in the accommodated in the same post. Even if there is no vacancy in the department, your lordship, the respondent authority can accommodate some other, your lordship. Then they themselves admitted, your lordship, that at that relevant point of time, there was no DLC. And accordingly, I have been instructed, your lordship, to file a fresh. And 2023, your lordship, I have filed representation. And accordingly, my matter was placed before the DLC. DLC, after you having gone through every pros and cons of the documents, eligibility and all, your lordship, have been recommended, forwarded to the SLC, your lordship. So this 36, your lordship, that after sending, forwarding proposal recommended to the SLC, they would consider my, your lordship, case in the next SLC, your lordship. So respondent authority cannot take the advantage of their own wrong or fault, your lordship. We cannot make to suffer for the inaction, negligence, and administrative delay on the part of the respondent authority, your lordship. should be decided on merit, your lordship, not on technical grounds.
Yes.
My lord, they have challenged their prayer is to place the SLC, my lord. So, my lord, the government will better position to whether this case has been placed before the SLC. I am for the department, my lord, the education department.
So affidavit
We have-
also not been filed, your lordship.
Affidavit.
Clear idea.
Okay, this question I don't know.
Madam, will be taken in the next week, madam.
And also affidavit not been filed, your lordship. Let the
That's okay, we don't need an affidavit in here.
Whether his name has been placed before the SLC or not, matter that instruction is required from the government.
It's here, we take it up on Monday.
Monday.
Anything you have to submit, please add that. He's made his submissions. Make your submissions, we don't need an affidavit in the matter. Authorized represented. On the prayer made by Duns Committee for the, your for
Government, madam.
So, on behalf of I'm a
Yeah, government has paid.
green paper, madam, green paper.
government advocate.
Government.
I am penniless.
Okay. Government
I can-
and the government advocate, the matters can be done today. 22/7/2026.
Madam. Complex, 20%.
You take your citations, you give it on that day. Otherwise, it may go missing.
Lordship.
Other matters will be adjourned.
Not, depublished, lordship.
Item number 16 was there. May I clear for any paper?
Give a date. 20/7.
In item number,
It goes after vacation, 20/7.
Madam,
Item
madam, it
17
is
also
taken after vacation, madam.
No, this, compassionate matters, already there is.
I'm.
Going to delay. No. 20%.
item 17 also, Lordship, date may kindly be fixed.
It goes to that same day, 22/7.
Lordship. Much obliged, Lordship.
It will.